and advised that she was recusing herself, and further advised that I find a replacement, which is what I did. And that is why, if you go back to the commission's proceedings, I had hired Mr. Mustafa Bachili as counsel when the commission was dealing with matters regarding Social Security and Housing Finance Corporation.
At what point did lead counsel approach you to declare the interest?
As in?
Was it before appointment or once the commission had commenced it?
Oh no, it was during the hearings. But like I said, which was normal, she was not counsel to all these other state-owned enterprises. But once we got to a point where there was potential conflict, she disclosed that conflict. And that's the point about conflict. All you're required to do is disclose it, and then it will be up to the person who has engaged you on the assignment to decide how best to mitigate the risk of that conflict. And I think she did that here, and she recused herself actually, and I appointed Mr. Mustafa Bachili.
Yes. However, my issue is with the timing. At what point was that conflict declared?
In the course of the proceedings, but before, I believe before the issue of Social Security was broached by the commission.
All right. Now I go back to the TOR phenomenon. You see, if this were the TOR, the legal notice were the TOR, let me concede momentarily to say that the TOR is are the terms of reference, then lead counsel would be looking at her terms of reference and see an evident conflict from the word jump, from the beginning. Do you agree? It is in the first paragraph, second sentence, a client.
Yes, she would have noticed a case of potential conflict at that point.
And when at the point of appointment, the question was put to her, did she declare that there could be a potential conflict?
Well, that's what I said. If you recall, my comment was that the question that I asked everyone was, is there any reason why you cannot perform this function? And obviously she said no. She had to consider it, by the way. It was not instant. She reverted and said no, there is no reason, but that if there was conflict, she would bring it to my attention. I do clearly recall that. In fact, to be fair to Mrs. Bensouda and to give her credit, when I first approached her as a potential candidate for judgeship in the Supreme Court, because again, we will get to that. I was doing a lot of headhunting around the time to look for people to man a lot of these positions. I approached her first to serve as a judge on the Supreme Court. It was in her office. I went to her office, just like I went to the other judges to invite them. She said to me, my commercial practice is such that it will be difficult for me to serve as a judge in this country. And so it was best for her not to accept the offer of appointment as a judge. So as early as my interactions with her, she has always been conscious or mindful of getting herself engaged in a situation that would potentially give rise to conflict. And in this particular case, I believe we should actually be applauding her for coming up and declaring this conflict and advising me to appoint another counsel in her stead.
So at this very point, I would, to a degree, agree with you. Indeed, when the conflict arose, she declared it. However, having said that, it could be argued that the conflict arose from the date of her appointment, because a month before, she received instructions from one of the very institutions that she was about to investigate. And mind you, that institution's would own about 3 of the properties, 3 of the assets that they would go on to deliberate on.
You know, Council, if I were to go through the list of corporations here and I am looking for a lawyer who has got all the, who satisfies all the criteria that I have outlined, including experience in the public service, etc., we will struggle to find a lawyer in this country who never dealt with any of these public enterprises. And in this case, Ms. Bensouda only dealt with one, as far as I knew, and as far as she brought to my attention, amongst a list here. I think it's fair to say that when that public body was to be, when the proceedings to look into the dealings of that public body were about to start, she recused herself. And that's what you need to do in conflict. You don't have to recuse yourself from the start because, like I said, you will struggle to find counsel who would meet all of those criteria and yet never dealt with any of these bodies.
Would you struggle to find such counsel within the ministry?
It was a deliberate choice to look for counsel outside. Again, it goes back to the issue of the degree of independence that we wanted this commission to have. We didn't want the commission to have any links with the government at all. We didn't want it to be independent only. We wanted it to be seen to be independent. And besides, I was struggling with my resources at the ministry. I couldn't. Again, I said earlier, I had to outsource the NIA 9 case to Mr. Gay to conduct the prosecutions because we were just overwhelmed at the ministry at that time.
Is the answer to the question that it was difficult to get somebody within the ministry?
I gave 2 answers. First was we wanted to make sure there was not only independence of the commission, but it was seen to be independent. We didn't want government. We didn't want it to be linked to the government in any way, except of course for the money, because the government has to provide the money.
And of course the reporting lines.
Well, there were no reporting lines. No. I don't know what you mean by reporting lines.
At the conclusion of the commission, they are bound to report.
It's a presidential commission of inquiry. It's the president who set up the commission.
Indeed.
They have to submit their report to the president.
Indeed.
But that's the extent of the link.
But you cannot delink them from the government.
Well,
in fact, one would argue that they are part of the executive.
Not at all. Far from it. They are an independent commission of inquiry. That's the letter and the spirit of Section 200 Council. Otherwise, why set up a commission of inquiry? Otherwise, why have the provision in the Constitution for the president to set up a commission? I mean, it's to ensure that there is independent fact-finding exercise and to advise the president and make recommendations on what actions to take to prevent recurrence.
So how come the lead counsel then came to you directly instead of going to the independent commissioners?
I was the one who appointed the lead counsel.
But
she was appointed by the attorney.
Once you appointed her, there were no reporting lines.
Oh,
she
no,
was answerable perhaps only to the commission.
Okay, let's put it this way. You think if she went to the commissioners, I don't know even if she did, she might have informed the commissioners. I wouldn't put it past her, knowing her level of professionalism. But let's assume she went to the commissioners to tell them. Are the commissioners going to appoint another counsel to replace her? It was not for the commissioners. It was for me as the appointing authority. So she had to come to me to tell me so that I could replace somebody. I could replace her with somebody else.
Precisely. You cannot delink the government.
No, you said reporting lines. Because when you say reporting lines, it denotes an obligation to be reporting to whoever it is about your work.
I believe I mentioned reporting. Not reporting lines. And,
okay.
I also clarified that at the end of their mandate, they would report to the president. And
well,
I believe you confirmed that it was a presidential...
They would submit their report to the president.
Yes.
Yes, but there was no obligation to report to anybody. We wanted them to be independent. They acted independently.
All right. So I see in one instance, the lead counsel would approach you directly. In another instance, TOR, it's left to the commission.
Well, yes, counsel. Naturally, I don't see an inconsistency there. The TOR is for the internal operations of the commission, how they're going to conduct their work, and that is up to the commissioners to determine that. The lead counsel is there to assist the commission. But in terms of her appointment, the Attorney General appointed counsel, and if she was declaring conflict, so that action will be taken to mitigate that conflict, she would come to the appointing authority, which was me in this case.
Now, the lead counsel had a team, didn't she?
I believe she was working with a team at the commission, yes.
And do you remember what that team composed of, or who that team composed of?
Like I said, I had this approach at the time. We do the hard work. We find the right personnel. We set up these activities in the form of these commissions. It was like churning it out from a production line, a production machine. So when we set up, we gave them, whatever support they needed. Once they take off, we focus on the next commission, because we had a line of commissions that we needed to set up. So I wasn't, in fact, if I tell you today, I'm sure many people will find this surprising. I have never watched a full episode on TV of any of these commissions, not even the TRRC, not one full episode. And that's because I just didn't have the luxury of time when I was in office to do that. It was always difficult. But
the team.
I know that we seconded one or two lawyers to assist her. Her team. I believe she also brought in a few lawyers from her chambers to assist her. But certainly there were one or two lawyers who were seconded to her team at the commission.
And those were lawyers from the ministry?
Indeed.
What level were these lawyers at the time?
I can't remember now. But I had instituted a deliberate policy to second lawyers from the ministry to each of those commissions that were part of the transitional justice process. It was my way of also building the capacity of the ministry. I wasn't looking at the immediate processes. I was looking at how we could sustain these processes as a country, so that when we build this capacity in the course of these commissions, that capacity will be at the ministry. And in the event that is needed in future, the ministry will not start looking outside. So I deliberately made sure that for the TRRC, the CRC, the National Human Rights Commission, the Faraba Banta Commission, the Jani Commission, lawyers from the ministry were seconded as a way to build their capacity as well. I don't remember what level they were.
All right, you do not remember what level they were, but then you've made the submission that the commission was to be allowed to conduct its work independently.
Absolutely.
What stops the commission from allowing other counsel to take over?
I don't understand what you mean. What stopped the commission from allowing who to take over?
Lead counsel came to you,
yes,
as soon as she realized that a conflict arose, right? What stops that matter being dealt with as an internal commission matter, since they were independent?
Oh no, the appointment of counsel was by the Attorney General. So it was the Attorney General who could replace counsel. I could have chosen to replace her with one of the lawyers who was seconded from the ministry. But again, it goes back to my point. We wanted independence, complete independence. And that's why I went to seek another private counsel to step in.
Yeah, but Mr. Tambedou, it can't be independent when the 80% of the staff are in fact from the government. And perhaps I'm a bit loose with my stats here, but I would say 65% were from the MOJ.
Which staff? The administration?
Yes.
They were seconded. Yes. But they were seconded.
So where is the show of independence there?
No, but they were under the direction and authority of the commission. They were not taking their instructions from the ministry. Apart from it.
That's not the insinuation. What my point is, your submission is that the commission was independent.
Yeah.
They could deal with internal issues as they please.
Yes.
Now, the issue of conflict, once commission has begun its work, is a matter for the commission to deal with.
Look, Council, I think you're mistaken. The issue of conflict is one that must be raised with the appointing authority, so that the appointing authority will take measures to mitigate the risk that that potential conflict could create. In this case, the Attorney General was the appointing authority of Council. Council properly raised it with the Attorney General. Even if Council, and I believe she would have raised it with the commissioners, it was by way of information only, because it was not the commissioners who were going to appoint another council.
Yes, but we're not speaking of appointment here.
But we're talking about replacing Council. You replace Council by another appointment.
Council was never sacked, was never removed as lead counsel. She remained lead counsel to the commission. I believe the conduct of certain proceedings was what was altered to substitute her for other counsel.
However you call it, whether it's by substitution or whichever way, there was another appointment. Even if it's temporary for a month or a week, it's still an appointment.
Yes, and I'm saying that since your submission is that the commission was independent, it could develop its own TOR and run and conduct its proceedings as it saw fit. What stopped the commission or the commissioners from, or even lead counsel from allowing other counsel to conduct the matter?
You want to know what stopped the commission from doing so? Maybe
Yes.
you should ask the commission what stopped them from doing so. But in my case, I think it was absolutely correct for lead counsel Bensouda to come to me and declare the potential conflict of interest, and for me to act on an interim basis to mitigate the risk that that potential conflict could create for the commission. And I did. And I appointed someone for a period. When the theme of social security was concluded, lead counsel resumed her activities on in respect of the other public state-owned enterprises.
Let me ask, who is responsible to decipher whether a conflict has arisen or not?
That's why I said right from the start that conflict is to be determined on a case-by-case basis. It depends on the circumstances. It depends on the parties that are involved in any particular arrangement. So there is no hard and fast rule here about conflict. It depends on the circumstances.
So in this circumstance, you stand by your testimony that lead counsel rightfully came to you instead of allowing it to be a matter for the commission.
But that's my point, counsel. The commission cannot appoint counsel. They do not have the power to appoint counsel.
But we're not talking about appointing counsel here.
But this is about appointing counsel to step.
No, it's not, Mr. Tambedou. With all due respect.
So what is it about?
Let's begin from the declaration. What is the appropriate forum to raise the conflict of interest?
Like I said, she could have raised it with the commissioners by way of information, but certainly to the appointing authority, which was the Attorney General in this case.
All right. Honorable Chair, I think we are at a deadlock.
No, we're not at a deadlock, counsel. Don't call it a deadlock. The thing is, I am telling you, you know, when you're making your declaration of conflict of interest, you make it to the hiring manager. the person who hires you, and that's normal in every system. And I am sharing my own personal experience with you, even given my current work, that when we have to make annual declarations of conflict, and we do it to the hiring manager. I don't want to be specific about that, and that's very normal. So
Yes,
in this case, I was the hiring manager, and she declared her conflict to me.
that's understood. But here we are dealing with a unique body. You yourself characterize this as an independent body.
Yeah.
Now, that independent body should determine its own rules, its conduct. You've given it leeway to determine so much. Why can't it determine whether a conflict of interest situation has arisen?
Well, perhaps if there was a dispute about whether a conflict of interest has arisen or not, it would have dealt with it. But here, as far as I know, there was no dispute. Council declared the potential conflict and declared it to the hiring manager, which is in this case was the Attorney General, and
Declared it to the government. I believe
you can say the government.
I would prefer to say the government, because the hiring manager would sort of denote that you are part of the commission.
Okay, but
So the government that was supposed to leave the commission as an independent body is who she reported to.
but it's the commission, but it's the government. If you want to use it's the government that appointed her in the first place.
Indeed.
So,
And this wasn't a case where she was being removed.
no, she was being recused.
Yes.
Yes.
For 1 or 2 cases.
In
Now,
the case of Social
why
Security.
it had to be the Office of the Attorney General to deal with that instead of the Commission
Because it
is
was
what I'm struggling.
because it was the Attorney General who appointed her.
But we're not talking about dismissal or appointing here. We're talking about a conflict of interest.
Yes,
I believe that conflict should be determined by the presiding officers.
and that's what I'm saying. If there was a dispute about the conflict, if there was a contention about the conflict, if there was one party who was alleging conflict and another party that was saying there was no conflict, then you expect the commission to step in and adjudicate. But in this case, you have counsel who comes and declares that there could be conflict if she continued in that role insofar as one state-owned enterprise is concerned. I think that was very, very normal. There's no dispute about it.
All right. I would still insist, Honorable Chair, so to avoid the back and forth, I would say we're at a deadlock, and I would leave that issue to the committee to decide. However, I would still want us to focus on when the conflict arose and when it was declared. I am of the view that the conflict arose on the 12th day of July, 2017, when lead counsel was being appointed, because of her prior engagement, the same engagement that warranted her recusal once the commission had commenced. So I'm saying, I am putting it to you that the conflict arose on the 12th day of July, 2017. What would you have to say to that?
You see, my little knowledge about fact-finding processes is not to adopt an adversarial approach to it. It should be more of an inquisitorial approach, because there is no us and them here. This is about establishing the truth and the facts. And so it is in our collective interest to make sure that this committee is well informed of the facts from which to derive their own views subsequently. And I am saying that conflicts do arise in the course of our work, whether they are at the start or they are in the middle or at the end.
But the question is, when did it arise?
Some you can foresee, some occur unexpectedly. But it's the ability to mitigate the risk when they arise. I think that is what you're failing to grasp here, Council. It's the ability to mitigate the risk that a potential conflict could create. And so, if, for example, I'll give you another example. If, for example, you are sitting in a recruitment panel and there are applicants for a job, and your wife is one of the applicants, and there are 100 more applicants. Because your wife is on the list of applicants, you can clearly see that this would amount to conflict. Are you going to recuse yourself right from the start from dealing with the other 99 applicants, or are you going to be involved in the recruitment process for the 99 applicants, and then when it's the turn of your wife, you recuse yourself as a result of the conflict? I'm trying to give an analogy here so you understand that just because you can foresee conflict doesn't mean...
I would indulge. I would indulge.
You see what I mean?
I'm trying to, but it's not quite the same.
But it is the same.
All right.
You have a situation of conflict. You're dealing with more people than your wife in this hiring exercise. You can see your wife is an applicant. Clearly, you can see there will be conflict if your wife's turn comes, but you don't get out of the hiring panel because of that. You sit in the hiring panel and you deal with the other applicants, and then when it's your wife's turn, then you recuse yourself.
All right.
So that's how you deal with conflict.
All right. To an extent, I agree. However, we're looking at the time that the conflict arose and how the two players dealt with it. Yes? And I'm sorry, but I have to drive this point home. That, let me take your analogy and indulge you. You see, if my wife was part of a recruitment, did you say the panel or part of the candidates?
She was an applicant, yes.
She was a candidate. You see, unless my wife decided to fight with me that day, but I would know before I even entered the room.
No, I'm saying,
and
assuming
fact,
you know. Assuming you know.
Yes, I'm answering. Assuming I know, I would recuse myself from the process because not only would I be conflicted with with my wife's session, but I would be prejudiced by other sessions because I would not treat my colleague's wife, if she comes into the room, my colleague's wife will not be treated fairly because I will have at the back of my mind that my wife's turn is impending. And the reason I say that scenario doesn't quite fit, I would amend that scenario a bit and say, if an authority asked me to select candidates amongst five candidates, and I know that one of the candidates is my wife, from the initial point where I'm being asked to select a candidate, I believe the prudent thing to do is to decline. Because not only can I not be trusted to preside over the session of my very beautiful wife, but I would be definitely biased if the other four come in the room.
I'm sure your wife is watching this. She will be happy.
Indeed. I intended that.
Okay. Look, Council, people have different reactions to conflict. Some would take a more pragmatic approach, others would take a more idealist approach. Your example is quite idealist, and I applaud that. But if I were to make that decision, I would approach it in the way that Council Bensouda approached it, and not recuse myself from the entire process only because there is a potential conflict in one instance.
Very well. The reason why I would flip your statement the other way around to say that it is in fact declining that is pragmatic and waiting for it to arise that is ideological. The reason I would state that is that this is a commission of inquiry. We're dealing with assets of an individual and their partners. Whether you like it or not, the evidence is intertwined. To sever the evidence is a messy affair. It's a cloudy affair. To say that I would wait until it arises when you are aware that it will inevitably arise. Now, I want to go back to your criteria. Your criteria was conflict of interest. That criteria was flawed from the beginning. You would agree with me. A conflict was impending, and that would have been the lead counsel would have had knowledge of that conflict from the 12th day of July 2017 when she received her appointment letter, along with the mandate of the commission, which is being referred to as the TOR. Correct? So let's make no mistake. Let's establish this. There was a conflict from that moment. That conflict was not declared. It robbed you of the ability to still offer the position to lead counsel.
What was the precise nature of that conflict, counsel? Wasn't it in respect of one state-owned enterprise? I'm not sure whether the evidence was linked in the way you said it. In fact, if you go through the Joint Commission report, each state-owned enterprise was dealt with separately.
Of course.
I do not see the direct links. The only thing that links all of those state-owned enterprises is the former president who was fleecing our coffers
Yes.
of our wealth. But otherwise, that's the only thing that links them.
All right, let me give you another link. Having read all the evidence before us, very tedious job, I can tell you that the accounts are invariably linked to the companies, just as they are linked to the properties, because you would need to withdraw money from public accounts. I believe that was the allegation levied on the former president. You take it from account A and invest it in an asset. Those two are invariably linked.
Yes,
you cannot separate the work of the commission in that manner.
I'm talking about in respect of the different state-owned enterprises, because what you're telling me now, which is quite correct, is monies were being taken from different state-owned enterprises and being injected in private affairs, and I think that is clear. Nobody is disputing that, and I believe when the commission proceedings were on, the focus of the investigations, which is reflected, I believe, in the report of the commission, was that each state-owned enterprise was treated separately, and the transactions between the former president and those state-owned enterprises were separate. So I do not see how you would find difficulty in understanding why counsel cannot just recuse herself from proceedings in respect of one state-owned enterprise and then continue her work in respect of the others, because there was really no link between the different state-owned enterprises.
I understand that, and it is regular for counsel to raise that conflict. The point at which it is raised is the contention here. Now, at appointment stage, one of the criterion, and I'll give you two criteria. One of the criteria was conflict of interest. The question was posed, and the Ministry of Justice, or the Minister of Justice yourself, was not made aware from the 12th day of July 2017 of the fact that lead counsel is counsel for one of the institutions. And mind you, while it might be one institution, that institution owned about 3 properties that were in question and other assets such as vehicles, tractors, that are all the subject of the commission. And just another link, another criteria rather, is you had mentioned public perception, that the government wanted the public to gain the public's trust, and show the public that they were doing work. Now here is an issue arising from the person that is meant to conduct the case before the commission, or rather the issues before the commission, and there's a conflict that arose from the date of appointment. Now, that conflict, if it were made known to the Ministry of Justice on the 12th day of July 2017, are you telling me that you would have still acted in appointing lead counsel?
First, her response to me was very qualified. There is no particular reason why she cannot carry out the work that I was going to assign her. And two, if there was going to be conflict, then appropriate action will be taken. And at the point where there was potential conflict, she did disclose that and appropriate action was taken. I would like to believe that even if she had raised the issue of conflict with respect to Social Security and Housing Finance Corporation, I would have had the same agreement with her that when we get to that point, she can recuse herself and then someone else will step in until Social Security is covered. I think that is very, very usual, counsel, in the professional world. There's nothing unusual about it.
I still maintain, and perhaps another deadlock, Honorable Chair, I still maintain that the issue of conflict with the appointment of lead counsel arose on the 12th day of July 2017 because she had a prior engagement with one of the interested institutions that had several assets on its belt, and that engagement was made on the 7th day of June 2017. Now, with your permission, Honorable Chair, I would want to proceed to other issues. I would leave that issue to the committee once more. All right, I would move from it momentarily and refer to MOJ 3K, Honorable Chair. Secretariat, if you could guide the witness.
Yeah. Yes.
Yes. So emoji 3K, I would I think I've made you read enough, Mr. Bensouda, sorry, Mr. Tambedou. I would go on to fast track it and just read. Emoji 3K is a letter that emanates from Ami Bensouda and Co. Corporate Legal Services. And it's addressed to yourself, the Honorable Attorney General. Solicitor General is copied. This letter was issued on the 24th day of July 2017. And it is termed engagement letter. It has the scope of work. Now, perhaps I would allow you to read 1A and B for the committee.
You want me to read it aloud or just to?
Please read it aloud.
Aloud. Okay. Heading scope of work. The scope of the work which I have agreed to undertake is as follows. The management and administration of inquiry processes and procedures. To pay particular attention to the terms of reference and the applicable law and to assist in ensuring that the Commission does not exceed its remit, i.e. its jurisdiction. And B, to assist in ensuring that there are appropriate procedures in place for 1. Document exhibit control and recording, 2. Identification and recording of assets before presentation to the commissioners. And 3. Analysis of financial banking records.
All right. Thank you so much, Mr. Tambedou. I would give you some information. The committee is in receipt of evidence that since the government had allowed the commission to come up with its own modus operandi, the commission, or rather, yes, the commission opted to have a system where the lead counsel is privy to every single document that comes in to the commission. Were you aware of this?
I expect that to be the case in a professional environment, absolutely.
Now, I go back to the conflict. Issue arose on the 12th day of July 2017 when lead counsel was being appointed. She knew that there was an institution that would render her a conflicted party. Right? Let me land. Sorry. The practice in the commission was that every single piece of evidence needs to be brought before counsel. Now, counsel represents Social Security. Social Security will inevitably submit documents. Counsel will inevitably be in receipt of those documents. Now, if you go to B, 1B, it says, to assist in ensuring that there are appropriate procedures in place for document, exhibit control, recording. That process would mean that she would be au fait or privy to the extent of evidence that is available to the commission. With that information in mind, do you still stand by your testimony that it was still proper to appoint her, or rather not to declare the interest from the 12th day of July?
I think it was proper for her to declare a potential conflict at the time that she did before the commission started its proceedings on Social Security and Housing Finance Corporation.
But was it proper that the interest was not declared on the date of appointment?
I think her response was qualified, and I wouldn't go as far as to say that the interest was not declared, but she had alluded to the fact that if an interest if an interest does arise or conflict does arise, she would avert my mind to it, which is what she did.
My point, Mr. Tambedou, is that a conflict did arise from the date of appointment, didn't it?
A conflict insofar as the Social Security is concerned.
Would you agree to that?
Insofar as the Social Security is concerned.
Of course.
Yes.
It was a conflict.
But whether it was a conflict before or after, the fact is she declared it and appropriate action was taken to mitigate.
Yes, but she declared it. She did not declare it on the 12th day of July 2017, the date of her appointment.
She might not have been as specific as she subsequently was, but her response to me was quite qualified.
Usually when...
Council. Can you allow us to, we can take 10 minutes break for prayers, and you can resume back. Otherwise, we don't have quorum and members will have to pray as well.
Very well.
Please, huh?
That's fine.
Meeting adjourned for 10 minutes for prayers.